So let's say Maria came up with the fees tomorrow. How
Right.
long would this process take? Would she have to wait years for legal status?
Well, VAWA scenario is usually 2 or 3 years. That's just how long it's taken them to adjudicate it. Now she's in removal, so it could take a lot longer. So let's say we move, she hires us, she comes in really quickly, she hires us, we file the I-360 for VAWA really quickly, but USCIS will take a year plus to adjudicate that. She may have a court appearance or two in between while we're waiting for USCIS to adjudicate it. Now that they've approved it, maybe we have a court appearance 2 years from now or a year from now. And maybe we ask the judge to terminate proceedings so we don't have to go. But the judge may not roll. The judge may not decide it right away. And that's what's happening now is we're just waiting and we contact and we ask and we write letters and we make phone calls, but the judge hasn't made a decision. The judge may not make a decision until we go to court. If we're fortunate, the judge will grant the motion. We won't have to go to court and she's going to have an interview at USCIS office, but that doesn't always happen. And every court appearance has a fee. Every interview has a fee. Every request of the court has a fee. Not every time we call them, but I mean, there's a fee to file the motion. And then maybe we have to go to court, maybe we don't have to go to court. So again, it becomes difficult to predict. I can only say what we charge for what we do, and I can almost always tell somebody what the next step is, but I can't always tell them what 2 or 3 or 4 steps are going to be because there are things that don't necessarily depend on us. If the judge doesn't deny the motion, if the judge grants the motion, then we know we're going to go to USCIS. Well, it's going to take a time for the file to be sent to the agency and for the agency to then call us for an interview. It's going to take time for the judge to make the decision. Now, if the judge doesn't approve the motion, then the judge will have to give us a trial date. Depending on the judge, that could be 2, 3, 4 years in the future. So it's hard to determine how long it's going to take because there are factors that are outside of our control. It's almost like the hurry up and wait approach. Hurry up, pay in full, give us all the documents so we can file your application. Then we wait until the government does something. Government could take 2 years, but once they've done it, now they make us move quickly. They don't, but we have to. It's not fair, but that's our reality.
Makes sense. And, VAWA actually sounds pretty complicated. So I think there's a lot of things that could go wrong. I mean, does Maria need an immigration attorney to get started on something like this?
Nobody needs an immigration attorney.
Okay.
The law doesn't require it. But the problem is she doesn't know what she doesn't know. Again, did she know that she qualified for VAWA when she came to the United States? Probably not. Did Customs and Border Patrol tell her? Maybe, probably not. If she doesn't, she comes in, doesn't speak to anybody, files for asylum. She's just going to go through the asylum process. Maybe she's fortunate and judge says, wait a minute, your spouse is a U.S. citizen? She sees the applications. Were you aware of? Maybe the judge says, did you look into? How often does that happen? Not often. But some judges do take that time and give that consideration. It's what they should do. But judges are so busy, they have so many cases, whether they want to or not, they're not looking for it. So they may not recommend it or suggest it. Or if they do, they may not give her the time to look into it. They might just say, listen, it's not my fault you didn't see an attorney. It's not my fault you waited 4 years to your trial date. And now we find out that you had something better that you could have done. Shame on you. And they'd be right. So the downside of doing it on her own is she doesn't know what she doesn't know. And this is the first application likely of this kind she's ever done. So maybe she sends the wrong form. Maybe she sends the wrong fee. Maybe she doesn't provide the right documents. Maybe that she waits 2 years and gets a request for evidence and then has to respond. Maybe she doesn't do a good job responding and gets denied. Maybe she doesn't know that she's entitled to employment authorization, so she could have gotten it and she doesn't get it all this time. So the law doesn't require her to have an attorney, but because she doesn't know what she doesn't know, there's so many ways where that could go wrong. And really, you only get one shot at this. I mean, yeah, she can file an appeal, but that's taking a relatively simple, controllable situation and making it much, much harder. I have an individual who hired me for an opinion. He had a family-based application out of Texas. And he was from Mexico, and he would travel back and forth, and he had identification travel back and forth while his case was applying. So this is 40 years ago. He's at the border. Officer interviews him. Actually, he's the one driving, but his passenger, his friend, is American, looks American, speaks fluent English, and him and the CBP agent, then it was INS, Immigration Authorization Service, had a conversation, and then my client understands that he was asked for ID. He presents his driver's license. He gets arrested for making a false claim to U.S. citizenship. He's like, "What are you talking about? I never said I was a U.S. citizen. I even showed you my employment authorization."